The Signature Bank Studios.
Only the biggest stories, only the biggest guests, and only the biggest opinions. This is AM 560, The Answer.
Top of the morning, Dan and Amy. A surprise ruling from the Supreme Court yesterday, and a disappointing one. I don't know which part of the Twitter files was confusing to Justices Coney Barrett, Kavanaugh, and Roberts, but wow. 6-3 decision that the federal government did not unconstitutionally coerce social media companies to censor content of a political and public health nature. I mean, again, the stories that Michael Schellenberger, Matt Taibbi, and others wrote, thanks to what Elon Musk provided, in addition to even some of what Facebook executives like Nick Clegg, emails that were unearthed as part of discovery in that case. Jay Bhattacharya, Dr. J from Stanford.
Yeah, what was his reaction? Because he was one of the victims of this.
He's one of the plaintiffs in the case, right? Because he and Martin Kulldorff, both friends of the show we talked to during COVID, they were censored for asking questions about COVID policy. And they were targeted by Tony Fauci and others. And then the public health officials inside the Biden administration turned the screws on executives at places like Twitter. Jay Bhattacharya tweeted, the court ruled that plaintiffs, Missouri and Louisiana, as well as me and other blacklisted individuals, lack standing to sue. This means that the administration can censor ideas and no person will have standing to enforce the First Amendment. Free speech in America for the moment is dead. It's a big statement, but it was definitely a bad day for the First Amendment and our First Amendment freedoms. There's no question about that. The argument, too, from Coney Barrett, who wrote for the majority, platforms moderated similar content long before any of the government defendants engaged in the challenged conduct and continued to exercise their independent judgment. It's sort of this, she almost comes up with like a benign coercion standard, as if there is such a thing. So because they were moderating the content, it was okay for the government to come in and provide some encouragement in particular directions as it pertains to their moderation of the content on their platforms.
And the White House was so happy. KJP, she said, this is going to help the administration, quote, continue our important work with technology companies to protect the safety and security of the American people after years of Republican attacks on public officials.
Yeah, I mean,
Please.
Boy, it's just really difficult to make out the logic here and this sort of cowardly punting of the issue on a standing technicality. Who would have standing then? I mean, in a sense, they focus on standing, but they also, the majority also sort of dismisses the idea that the government acted inappropriately here, using cutouts to do its bidding, essentially.
Yeah,
to do what it couldn't do legally, which of course they can't do legally either. In his pretty scathing dissent, Justice Alito, the court shirks the duty to tackle the free speech issue, and thus permits the successful campaign of coercion in this case to stand as an attractive model for future officials who want to control what the people say, hear, and think. That is regrettable. What the officials did in this case was more subtle than the ham-handed censorship found to be unconstitutional in Vullo, but it was no less coercive. And because of the perpetrators' high positions, it was even more dangerous. It was blatantly unconstitutional, and the country may come to regret the court's failure to say so.
This is a real danger to democracy.
I hope it's tackled tonight. I hope Trump goes after some of the justices he nominated and that were confirmed. That would be Barrett and Kavanaugh, because I think they got this one wrong, and it's a bad one to get wrong. Professor William Jacobson is the clinical professor of law and director of the Securities Law Clinic at Cornell. He's also the founder of LegalInsurrection.com and the president of the Legal Insurrection Foundation, as well as the Equal Protection Project. Professor Jacobson, thanks for joining us. Appreciate it.
Thank you for having me back on.
So who got it right, Alito or Amy Coney Barrett?
Oh, clearly Alito. I mean, this technically was what they call a standing decision, that the court ruled that these plaintiffs did not have the legal right to sue for injunctive relief, so future relief, because they had not shown that they were subject to future threats of censorship. So in a narrow sense, that was the ruling. And in fact, at one point in one of the footnotes, they say we are not reaching the merits of the controversy. But of course, as you've noted, sprinkled throughout the majority opinion are various disses on the substance of the claim here. So while that wasn't technically the ruling, and I did see one of the attorneys in the case for the plaintiffs say we're going to continue in the district court for damages, it's a pretty devastating decision, because if these plaintiffs don't have standing, then who does? Which is the question you asked.
Yeah.
One of the participants asked that you quoted. Who's going to be able to bring this? Basically, nobody. So,
the other thing too is so you didn't show threat of future censorship. Past censorship is an indication of a threat of future censorship, particularly if you green light it, isn't it?
Yeah, exactly. And so basically what this says is not only what we kind of already knew, is that the platforms acting on their own as private parties can do whatever they want. But it goes further, because it basically clears the way for the government to tell those private actors through a variety of coercive measures or coercive language, because all of these entities are highly regulated in various ways by the federal government, that can pressure them to do that censorship in the way the government likes. And that's the reality of it. It's almost like the majority, and particularly the three quote-unquote conservatives who went with the majority, Barrett and Kavanaugh and Roberts, are not living in the real world. In the real world, these platforms react to government pressure and act accordingly. And that's what the evidence showed here.
Well, that's
this loss.
Sorry to interrupt, but I mean, that's what's so unnerving about it. It is so wildly naive. I mean, Kavanaugh, Roberts, Coney Barrett, they can't be that naive. It's the equivalent of the protection money guy coming to your store and saying, "Boy, I'd sure hate to have something happen to your business." Well, he didn't threaten me. I mean, he didn't say, "I'm going to do something to your business if you don't pay me." He didn't use those explicit words. He just said it would be terrible if something happened to your business. I mean, that's sort of the way and they say, well, there's nothing explicit. There was no direction. There's no direct coercion. But all of the context was clearly of a censorious nature. I mean, it's a joke.
Yeah, I mean, it's like you say, if they come up to you and say, "Nice kneecaps you have there." Shame
Yeah,
if
right.
something happened to them. Okay. Like, didn't say, "Tomorrow I'm going to break your kneecaps and therefore you can go into court and have standing to get an injunction." No, it's the government saying, "Nice business you have there, Facebook, Meta. Shame if something happened to it." That is enough of a threat that I think injunctive relief is warranted if you're one of the people who were censored. And so that's really the issue here, is that this is an otherworldly sort of decision based on, and I think the cases they cited were from, dozens, if not, almost 100 years ago, about, presidents making comments about media and things like that. Jawboning, I think, is the language they use. This is a totally different world. The federal government could really mess in a big way with these platforms, and by putting pressure on them. And so, I mean, it's legally, I think it's wrong on their standard for standing. And as a practical matter, it means social media discussion and social media vibrancy is gone. It will be left wing even more than it is, because they know that nobody can do anything.
Now,
if you feel you're being
I'm sorry. Go on. You feel you're being what?
If you feel you're being throttled, You can't go to Facebook and say, please give me your emails with the government. They're not going to give that to you. The only reason we had this evidence is because there was a lawsuit. And there were subpoenas issued by, I think it was the state of Missouri, subpoena power. Normal citizen can't go to Twitter or to now X or to Facebook or to Instagram and say, please give me your documents. They're not going to do it. They'll laugh at you. They won't even respond. So that means that the courthouse door has been shut as a practical matter.
All right, the Supreme Court still has a number of decisions to render. How do you think they're going to decide when it comes to former President Trump's presidential immunity case?
Well, I think it's going to be the three nominally conservative justices. So as soon as we see who writes the decision, we will know. Okay, if it's Roberts, it's going to be a middle-of-the-road sort of thing. So I think what's going to happen is a mixed verdict, which is that he has some presidential immunity. It's not absolute to the full extent that the President Trump claims it is. And I, would not be shocked if they even use the example that Trump uses about him shooting somebody in the middle of Fifth Avenue. So I think we will get a decision to say that would not be covered by presidential immunity, but clearly acts taken as president would be. And that middle ground, we'll kick it down to the lower court and let them figure it out.
He is Professor William Jacobson, clinical professor of law, director of the Securities Law Clinic at Cornell, founder of LegalInsurrection.com, and president of the Legal Insurrection Foundation, as well as the Equal Protection Project. Professor Jacobson, thanks as always.
Great. Take care.
Thank you. And he joined us on our turnkey.pro answer line.
Before you see it on TV, share it on Facebook, or read about it in the paper, hear it here first. This is Chicago's Morning Answer on AM 560. The Answer.
At Signature Bank, going the distance for business banking customers is what we do every day. We understand that business owners have a strategic mission, a drive to succeed, a plan for growth, and don't have time to wait for a bank to respond. With Signature Bank, you not only have a banking partner that has roots right here in Chicago, but our decisions are made locally too. Signature Bank knows that when you have a question or problem about your business, you want answers. You need someone who will pick up the